This is chapter 6, second part for employment standards legislation in BC. So in this second part, we'll resume talking about the minimum standards in the Employment Standards Act. It is time now to look at the leaves. So yes, look at the statutory leaves. So they are maternity, parental, family responsibility, bereavement, duty, jury duty for armed forces, reservist, and those two new ones in 2019 and 2020, the critical illness and injury leave and leave respecting domestic violence. So, as a general rule, the statutory leaves, they are non-paid leaves. When the leave ends, the employee has the right to return to work. It is important to mention that as of today, 2021, January, there's no statutory right to sick leave, either paid or unpaid. It seems the government wants this changed, but it has not changed yet. So as of today, if you have a right to sick leave, it means your employer has given you as a benefit. Okay, so the employer is not required to give any sick leave, but if you have paid sick leave, then it becomes a benefit. So maternity leave, up to 17 consecutive weeks of unpaid leave, but then you may be eligible for EI, employment insurance. The payment there is up to 15 weeks. We'll see this in detail, but I can anticipate that employment insurance is federal. So that's why the leave and the payment, they are not the same. They could be the same, but they are not. The 17 consecutive weeks, they are in the Employment Standards Act of BC, and the eligibility for employment insurance is in federal legislation for EI. And there's no minimum period. You can leave for 1 week if you want, up to 17. Can be extended. So if the maternity leave is taken along with the parental leave, so there will be an additional of 61 weeks. So the total will be 78 weeks, 12 months for such a leave. And it can start within 12 weeks of the due date. If the leave is not taken before birth, it can be taken up to 6 weeks after birth or termination of pregnancy. Sick leave is not a statutory leave, but if it is as a benefit, is separate. And once the pregnancy leave begins, it must be taken all at once. So let's say you want to take just 2 weeks as maternity leave. Okay, so you have to take it all at once. You want to take the 17 weeks, you take all at once. Okay. So question here, you may pause. So Fatima is a part-time employee, began to work for her employer 5 months ago. She's not eligible for pregnancy leave or maternity leave. under the Employment Standards Act because she has not reached the threshold of 52 weeks working for this employer. Is this true or false? This is false. In BC is false. In Alberta, this would be true. There's no minimum work length of service for someone to become eligible to maternity leave. Parental leave. So how much? 61 consecutive weeks when taken after pregnancy leave, or 62 consecutive weeks if pregnancy leave was not taken. Okay? It is available to any parent, could be the birth mother, father, could be same-sex partner, adopting parent. And both parents may take full parental leave, even if they work for the same employer. So it's a great leave here. So it has to start within 78 weeks after birth. If it's added to pregnancy leave, then it has to be started immediately after the end of the pregnancy or maternity leave, actually, as it is called. And the employee would need to give 4 weeks notice to the employer. But if the employee does not give such a notice, there's no penalty. Family responsibility leave, so up to 5 days per year. What is this leave? This is for the care of a child or any other member of the employee's immediate family who is considered to be immediate family. Could be spouse, could be child, parent, any guardian, sibling, grandchildren, grandparent, or anyone who lives with the employee as a member of the employee's family. Let's say a cousin leaves, an uncle, an aunt. And so it is for the care of an immediate family member, and it may also be used for educational responsibilities. Let's say attending graduation, meetings with teachers, etc. Compassionate care leave. So this is 27 weeks to care for a family member that has a medical condition that is theoretically terminally ill. So most cases I would say terminally ill, terminal illnesses that come to my mind is actually one. Cancer. My father passed away with cancer. I don't mean all cancers are terminally ill. No, that's not what I mean. But some, in some circumstances, cancer is a disease that comes to my mind as a terminally ill one. So if a family member has such a condition, the employee can take up to 27 weeks leave within a 52-week period. So within 1 year, you can take up to 27 weeks. And it does not need to be taken consecutively, but it has to be taken within this year, the 52-week period. In the very fortunate event the family member does not pass away, you can take another 27 weeks after that 52-week period. Okay? A certificate from a medical practitioner or nurse is required because there has to be objective evidence of the terminal illness. And Family member here is a bit broader than immediate family. So a close relative also counts here. Again, in that case, um, here I said anyone who lives with the employee as a member of the family. So if a cousin lives with the employee, so you could take the leave for family responsibility. Here, you could also take a leave for a cousin, but the cousin doesn't need to be living with you. So that's the difference here, and that's why here it is broader. Bereavement leave. So you have up to 3 days leave on the death of a member of immediate family. Does not have to be consecutive days, could be for attending the funeral, and may start on the date of death. This leave respecting disappearance of a child. So if a child uh, disappears and based on the circumstances, such disappearance is probable to be related, is probable to be a result of a crime, then the employee will be entitled to unpaid leave for up to 52 weeks, up to 1 year. It can be taken 1 unit of time or more than 1 unit of time. So you take more time, months now, then you return to work, and then more months, more weeks, but up to a total of 52 weeks. If the child is found alive or dead, then this leave ends, or it ends at the 52nd week. There's the leave respecting the death of a child. So if a child dies, the employee will be entitled to up to 104 weeks, up to 2 years. Again, it's unpaid leave. It has to be taken on the day the child dies or the date the child is found dead, in case the child was disappearing, and can be taken in more than 1 unit of time, so different periods, as long as the employer has consented. Jury duty. So anyone who has to serve, who is required by law to serve as a juror, they may leave. Reservists leave. So members of the reserve force of Canadian forces, and this is also an unpaid leave for the duration of the deployment, and the employee is required to give the employer a 4-week notice of the start and end date. But again, if the employee does not give such a notice, there's no penalty for failure. Critical illness or injury leave. So this is new from 2019. This is to take care of a family member whose health has changed significantly as a result of illness or injury, and the life of the family member is at risk. So I know someone with COVID-19 in serious condition may be admitted to the hospital. You cannot go there, cannot visit because of contamination, but that could be a case here, except for this contamination part. But let's say the patient recovers, but then has some side effects or some issues after recovery, then could be an example here. The leave is up to 36 weeks. for a child and up to 16 weeks for someone over the age of 19. And it ends in the last day of the week when the family member passed away, or this 52 here should not be right, or after the 36 or 16 weeks after the leave began, as just mentioned above. Another new one is leave respecting domestic or sexual violence. So the employee is entitled to 10 days per calendar year on situations related to domestic or sexual violence, plus additional time if necessary, but there's no limit or number here. This is also unpaid leave. So when the employee is on the leave, they have the right to be reinstated. When the leave ends, the employee has to be reinstated if there's no, if the same position the employee had before the leave is not available. So a similar position has to be offered with the same earnings. Benefits have to be in effect during the leave, and if the employer's operations have been suspended, then the employer has some time before they reinstate, but they have to reinstate as soon as operations resume. And the period of leave is included as time worked for vacation entitlement, for raises, for benefit plans, pension, medical, etc., but not for vacation pay. So when you are on a leave, statutory leave, you are not entitled to get vacation pay. And all leaves, during all leaves except for the reservists, Canadian Forces, the employer continues to pay the premiums for the benefits. So during the leave, the employee keeps on enjoying the benefits they had. And the employee also has the right to be free from reprisal. The employee cannot be penalized because they are eligible to go on a statutory leave, and they actually take such a leave. That is, if there's reprisal, the employee is dismissed. As soon as they return, there may be grounds here for wrongful dismissal. Termination pay and notice. We will discuss this in details in chapters 13 and 14 when we discuss wrongful dismissal or dismissal without cause and dismissal with just cause. So we'll discuss this in details there. So how is the employment standards legislation or act administered and enforced here in BC? So as we saw in the beginning, it is a complaint-based system. There's no lawsuit here. Lawsuit will be only related to wrongful dismissal and constructive dismissal. So two topics we'll see in the future. Again, you are not being properly paid over time. You are not being given your eating period break or any other rights that you believe are being violated by your employer. You will not sue the employer, but file a complaint with the employment standards branch. So, but you have a deadline. You have up to 6 months of the last day of employment to file such complaint. If it's longer than 6 months, then you don't have a right to complain anymore. And if it's a complaint related to the hiring process, then the 6 months is counted from the date you suffered the violation, the alleged violation. And the deadlines, they may be extended by the director of employment, but that's not uh, usually the case. In most cases, only if there were extenuating circumstances for an extension. If not, uh, the 6 months uh, period to file a complaint has to be complied with, has to be respected. If the employee is unionized, then they have to use the grievance process in their collective agreement. Remember, we discussed this. It's a requirement for all collective agreements to have grievance processes. And as I said, the employees will not sue in court for those standards, but they may sue for wrongful dismissal, for compensation they may be entitled to. And you can pursue both the complaint with the employment standard branch and a lawsuit against your employer together at the same time. The employment standard branch, they encourage voluntary compliance of the act, of the legislation, act and regulations. They may also initiate proactive inspections if they want to, if they have received many complaints, could be anonymized complaints. And they also investigate complaints and they provide remedies, any remedies they find fit for those complaints. Employees are most likely encouraged to resolve their issues directly with the employer. By the way, a self-help kit is provided by the employment standards branch. I have also provided this to you as a handout, just in case you want to skim it over. But then if the employee and the employer are not able to solve the issue by themselves, then the employee may file a complaint, and the employment standards branch will give the employer an opportunity to respond, and then the director may investigate or not by compelling witnesses, inspecting the workplace records, etc., and then rendering a decision, coming up with a decision on that complaint. The decision, known as determination, will happen if there is a violation, and the orders available, they are an order to comply with the Employment Standards Act, to cease the wrongful act or acts, pay wages or other compensation if the complaint was related to payment, and eventually reinstate the employee if the employee was dismissed based on a wrongful act. The director also has the power to post a notice in the workplace, the notice of the contravention, make other orders as they find appropriate, and penalties for wrongful act of employers, they range from $500 to $10,000. So it depends on how serious the wrongful act was or the contravention was. The decision of the director can be appealed to the Employment Standards Tribunal, and then the decision of the tribunal is not appealable. So the decision of the tribunal is final, but parties may submit the tribunal's decision to what is called judicial review. The judicial review is a quite complex topic, but very briefly saying, it is when the courts are called to review the decision of an administrative tribunal. And courts usually don't like to change the merits. Courts, they usually defer to the decision made by the tribunal. However, they may change the merits or order the tribunal to render a different decision if they find violations in the due process of law, in the fairness. For example, one of the tribunal members issued a biased determination, or one of the parties did not have an opportunity to produce evidence. So those are procedural issues. Issues that may have taken place during the complaint, um, either during the investigation and determination by the director or in the appeal of the tribunal. So those procedural issues, the courts, they look very closely to them, and then they may change the merits of the decision. But if they don't see any issues with the procedure, they most likely accept and uh, uphold the decision of the tribunal. And the last aspect here is that violating the Employment Standards Act is also an offense, criminal offense, under the Offense Act. Not criminal, but it's an offense. So when I say it's an offense, it means it's punishable under the Offense Act, but they are not usually used. So the Employment Standards Branch, they usually don't use them. They believe that the administrative remedies and penalties under the Act, they are adequate. They don't rely on the Offense Act. But just as information, fines here are up to $2,000, and there can be even an imprisonment for the employer's representative, directors, senior executives. All right, so that's the end of the second part of Chapter 6, Employment Standards Legislation. Thank you, bye.